when hiring a business litigation attorney, and that is getting nickel and dimed by your attorney. My name is Dave Scriven-Young. I'm an attorney in Chicago, Illinois. I do commercial litigation, construction law, and environmental law. I also host the Lawyer Lifestyle podcast and the Lawyer's Emotional Intelligence Book Club. Usually today I go live to do a live taping of the Lawyer Lifestyle podcast. We're not doing that today because actually we have a pre-taped interview going out for the Lawyer Lifestyle podcast. The interview is with Dr. Dennis Cummins, and he's a gentleman who specializes in communication, especially for lawyers and medical professionals. So it should be a really interesting conversation for you all. Essentially, what he talks about is how to get on stages and how to use stages in order to build your business. And stages can mean a lot of different things. Yes, of course, it can mean, getting a speaking role at a conference or something like that. But it also means something like what I'm doing, going live on social media. It can mean getting on as a guest on a podcast. It can mean a lot of different things. So if you want to learn more about how to use communication, how to get onto stages so people can hear your message and what your message should sound like when you get on that stage, tune in tomorrow for the Lawyer Lifestyle podcast, tomorrow, Tuesday, July 14th, my interview with Dr. Dennis Cummins, part of the Legal Power Players message that I do every Tuesday. So let's get into the message for today. And by the way, if people have legal questions, if you are a young lawyer and you want to be mentored, I'm here for that as well. Again, I go live every day at 8 a.m. Central to give my message, to answer legal questions, and to, when I was a young lawyer, I didn't really feel like I had the mentorship that I needed. And when I did have a firm mentor, it often was difficult to, summon up the courage to, really ask the tough questions for my mentor. So I wish that there was some sort of online resource, and that's the one that I'm trying to provide today. So if you're a young lawyer and you have questions you've always wanted to ask an experienced lawyer, come on in the comments and let me know what your question is. So let me get into the content for today. So again, one of the things that I've been thinking about is, over my career, I've been with a couple of different firms. I've dealt with a lot of different attorneys over the years. And one of the frustrations that I've seen that I've seen clients have over the years is they get nickel and dimed by their attorneys. And that comes, I think, in a number of different ways. First is access to legal research. So what does that mean? I'm not talking about the time spent for the attorney to do the research. What I'm talking about is the actual access to the legal research program. Every lawyer needs one, especially if you do litigation. I think, when I say every lawyer, maybe not every lawyer needs it, but certainly if you do litigation, if you're writing briefs, motions, filing complaints, answering complaints, all that kind of stuff, you need access to some legal research program. When I grew up in law school, it was just sort of like getting into legal research programs. We basically were on a two-track learning system. One was going to the law library and doing research using the legal research books. And then on the other hand, they were also teaching us computer-assisted research, things like Lexis and Westlaw as well. So the question is, should you be charged as a client for access to legal research? Well, again, I think, one of the things that I've talked about in this series is that you really have control over that. Number one, when you want to find an attorney who's going to, promise an engagement letter not to nickel and dime you. So if you don't have to be charged for computer-assisted research, at least the access to that program. Second is, photocopying. And although no one does faxes anymore, but I've seen that done as well, where, firms will charge, 20 cents per page, 10 cents per page for copying or even printing. I've seen where people actually have to, as an attorney, you have to type in your code, you have to type in a client matter number, so you're charging it to somebody. And it's another way that I've seen, attorneys nickel and dime their clients. Also with the consultation. Now, I think there's good arguments on both sides on the consultation piece. I know attorneys who actually charge $50 or whatever for a consultation, and I think that makes sense for some practice areas. But for something like litigation, it's a pretty sure bet, I think, that your potential client is going to show up for a meeting because they have a legal problem or they have a lawsuit either that they want to file or that they have already been filed against them. So it's pretty safe bet that they're going to show up for an appointment. And I think that's what that $50 or consultation fee is for, is just to ensure that the client has some skin in the game, and just to make sure that they show up for the appointment. So that's another piece. And then the last piece is strategy and communication. I've seen many times, and I've heard of lawyers who they charge for every email that comes in the door. They charge for every short phone conversation that they have with the client. Now, again, I'm not saying that lawyers shouldn't charge for communication. I'm just saying that there is a certain a threshold, at least the way that I practice, that not every email needs to be written down as a 6-minute time increment, because as for people who don't know, attorneys bill typically in quarter of an hour or tenth of an hour increments. So if you're a client, you send your attorney an email, that attorney, if he's writing down every single thing that happens, you're going to get charged 0.1, and that's going to be times the hourly rate, or 0.25 possibly times the hourly rate for even just receiving and reviewing that email. So what I do is something called the Efficient Litigation System, which essentially means I take your budget and your goals in mind in the litigation into account when we do the billing, when we do the budgeting, and we make sure that the tactics employed really reflect your goals and the budget. So for example, we don't typically charge for access to a legal research program. We don't typically charge for photocopying and the like. Consultations, we always provide a free consultation because we really feel like as an attorney, I want to get the best background possible into your case, and the only way that I'm going to do that is if we spend sufficient time for me to understand who you are, what your business is, what your legal problem is, who the opponent is, what your goal is. So many things that I need to know just in that initial consultation to ensure that, I think you're the right fit for me as a client. You think that I'm the right fit for you as an attorney, and that the case itself is a good fit, for my firm, because not every case that comes in the door is a good fit. And so, and obviously we have things like conflicts checks and the like, but I really think, having a fulsome conversation and that initial consultation is really helpful, to me at least. And if I feel like I'm charging somebody for that, especially by the hour, that's a hard thing to do. So I always provide a free consultation. And then, the last piece is providing a little bit of free time for that strategy communications piece. Because I think, probably the most important thing that we do as an attorney is that we have to make sure that we're communicating well with our clients, and that clients can feel free to communicate with us. Now, I don't provide, a complete free communication. Call me whenever you want. That's not what we do at our firm. That's not what I do in my personal practice, because of course, that can get out of control. So I provide, 2 hours of free strategy and communication. So, if emails, you can feel free to send me an email. I can feel free to respond to you within that, 2-hour piece per month. And it's just really important for, to maintain the lines of communication between client and attorney. So I think that's it for the message today. It's a really short message, but just really important for people to understand where I'm coming from, and that, again, clients really have more power than they think they do when coming into that attorney-client relationship. The best thing that you can do is get things spelled out in your engagement letter, get things spelled out when the attorney initially retains you, that, what's going to be free, what's going to be charged. And, you can make those changes, suggest changes. And if you don't find an attorney that does that for you, go to somebody else, because there's plenty of people who, use a system that allows, free-flowing conversation, that allows, good communication between attorneys and clients. And I think that's certainly what I do at my firm, using the Efficient Litigation System. So appreciate everyone jumping in on the live stream today. I'll be live again tomorrow morning at 8 a.m. Central to provide, I think tomorrow is going to be another live taping of the Lawyer Lifestyle podcast. And again, if you have legal questions you want to ask an attorney, and then additionally, if you're a young lawyer and you want to be mentored, you've always wanted to ask, a question about, what's going on in your practice, I'm happy to answer those as well. So take care, everybody. Stay safe, stay healthy, and I will see you again tomorrow at 8 a.m.